Welcome to the Emerging Litigation Podcast, a co-production of HB Litigation and Critical Legal Content, custom content for law firms and litigation service providers, and the newly formed VLEX Fastcase, your world of legal intelligence, and our friends at Law Street Media. I'm your host, Tom Hagee, litigation content producer, an enthusiast, and an average bongo player. Contact me if you have an idea for an episode. In addition to often being polite, I'm always looking for new twists on the law, whether it's a new regulation, legislation, or an important new opinion. Or it could be a development in the world that will test existing law, or anything you're dying to share with other litigators, organizations, or individuals. And if you like what you hear, give us a rating. That always helps. And now, here's today's episode. Today we're going to talk about alternative dispute resolution. Rather advanced dispute resolution, as my guest seems to put it. And I think he's right. And I know what you're thinking. I only choose funny topics. It's true. I do try to find humor in most things. It's a survival mechanism. And ADR may not be the richest source of guffaws. You might think that. But I'm sure a competent comedian could do a lot with it if only we knew one. But you've just got me. I might say, for example, if they produced the movie 12 Angry Men today, it might be titled One Patient Listener. It'd be a blockbuster. And I can say this, though. I do know some mediators. All I can say about that is that patience, sometimes it's merely a facade. There might be some holes in their drywall at home. I did see a couple of ADR cartoons. A cartoonist named P.C. Vey showed a client and his attorney walking down the street, and the client said, I'd like to avoid a costly and embarrassing trial, but I could use the media exposure. No one would ever do that today. Now, would they? Another one named P.S. Mueller, his cartoon had two gunfighters in the Old West. One of the gunfighters noticeably has his holster is empty. He says, my gun's in the shop. Let's establish a dialogue. That may be the best tie-in today, since the gunfighter may have found buying another gun was just too expensive, kind of like litigation. How's that for a segue? Aggregate annual litigation costs in the United States, they vary wildly depending on who they come from, of course. Those in favor of tort reform, those with the corporate bent, like the Chamber of Commerce, they'll come in with cost estimates of around $430 billion. And that was a few years ago. Others, when they add in indirect costs like lost productivity and economic damages, they come up with more than $1 trillion or $1.5 trillion in cost. But it's safe to say it's billions, maybe $250 billion in domestic litigation costs. Let's just go with that. Half of which can go toward motion practice and discovery. According to statistics compiled by Statista, more than $5 billion is spent on employment litigation alone, and $4.5 billion on commercial litigation. IP litigation, product liability litigation, and real estate, they each account for between $3 billion and $3.5 billion. And as any litigator knows, a resolution can take 3 to 5 years on average. I've seen them, of course, go more than a decade before a resolution is reached in court. ADR is increasingly attractive these days. Its benefits were put on full display, particularly during COVID. It's obviously more convenient, especially if we're talking about cross-country or cross-border disputes. An important side effect of litigation expense is the access to justice. Everyone will have disputes and conflicts in their lives, but not everybody can afford to go to court. So there's that. More and more ADR is moving from mediation to arbitration, apparently, according to AAA, the American Arbitration Association, because of the perceived finality of going to a panel. AAA says there were 25,000 ADR cases filed in 2020. That was the year of COVID. That's nothing, of course, compared to the 400,000 federal suits filed a year, and some estimates say as many as 60 million state suits are filed. But hey, it's something. Of course, not everything is appropriate for ADR, but much is. That's what I know. Here's somebody who knows quite a bit more. His name is Rich Lee. He is CEO and co-founder of New Era ADR. We talk about hot topics and issues involving advanced dispute resolution and the role of his company and himself in supporting this work. Before New Era, Rich was general counsel at a financial tech company that he helped build, grow, and sell. Rich also serves as an advisor, board member, and investor in technology startups and venture funds, and in a leadership role in the Economic Club of Chicago. He serves on the nation's Leaders Council on the Legal Services Corporation. That's a U.S. Senate-funded 501c3, and on the board of the Illinois Legal Aid Online Group. He has his law degree from Loyola University, Chicago School of Law, and a Bachelor of Science in Bioengineering from the University of Illinois at Urbana-Champaign. And with that, here is my interview with Rich Lee of New Era ADR. I hope you enjoy it. Rich Lee, thank you very much for talking to me today.
Thanks for having me.
So let's give some people more background about you and your company. What interested you in starting an ADR company, and then tell me what's different about it from other ADR providers.
Yeah, so there's four of us who started the company, and we're all kind of experienced folks in the legal space. Three of us are ex-general counsel, myself included, and we really built this to solve kind of that age-old problem that we've experienced over and over and over as legal and compliance executives and organizations, which is why does it cost so much to resolve a legal dispute? Right. And why is it when we hear the word lawsuit, whether you're a consumer, an employee, or an organization, right, we immediately, picture and imagine a 12, 24, 36-month slog, right? And that's kind of the foundation of all decision making, right, in litigation. If you think about it, why, if you set aside the cases where, somebody's done something wrong and it's very clear cut, right? The question of, do you pursue a case, or do you settle, or do you just, acquiesce and not pursue it at all? A lot of it is driven by how much do I want to engage in the pain and expense of the current process, right? And I can't tell you how many conversations, I've had with past CEOs when I was general counsel. I was general counsel of a couple different companies before I launched New Era, where I had to tell them, we have a really good case. I can win this either on the plaintiff side or the defense side. Like, I can go collect the amount of money that we're owed, or I can successfully defend this lawsuit, but I think we should settle, but I think we should just let it lie. And it's always because of, it's not worth it, right? And that's that business decision you hear folks talk about in litigation, about settling. But the business decision is really, do we engage in the pain? Right. And so for us, the reason we started New Era was we recognized, like, certainly we were going to build the tech. Like, we all come from the tech world. We wanted to build the technology platform to facilitate arbitrations and mediations, right, and make it just incredibly accessible and easy to use. But it was very clear to us early on that, if we built the tech, but we didn't change the underlying rules, and the underlying rules were just the same rules that exist today, right, in the court system, legacy arbitration platforms, then it's not going to be any better, faster, or more efficient. It's just going to be the same pain, but on a nicer looking platform. And so for New Era, we went a step further and said, let's create that alternate platform, and let's actually rethink, right, like what of all the procedures that exist in courts are truly necessary for what we like to call, like the core 99% of litigation, right? Which is, we recognize, right, that there's always going to be a set of litigation that should stay in the courts and that should take a long time. You think about trade secret misappropriation cases, patent infringement, IP infringement cases, securities fraud, I can go on, right? But that's actually not where most organizations feel the pain. It's actually the remaining 99%, right? The $2 million breach of contract claim, the employee, dispute, or the consumer dispute. And I say this from the corporate side, but then from the plaintiff side, it's the same, right? That, like, you're making decisions about whether to pursue a case, and you as a plaintiff's attorney are making decisions about whether to represent a client or pursue a case because of the pain and the expense of the existing process. So we distill that down to, this is all a product of, it's a product of the existing system. So we sat down, rethought, a lot of the different kind of areas of litigation, and created our own set of procedures that gets cases to resolution in 60 to 100 days. right? Versus the 12, 24, 36 months people are just used to. Um, and all of it's still preserving, a lot of the core elements of litigation as we know it, but just rethinking and modifying different areas to make it more efficient for both sides, right? And so the point of it all simply being, let's just get parties to be pragmatic, get to the point, present their arguments, have their arguments heard by an experienced arbitrator or mediator, and just get it resolved.
So it sounds like part of what I'm just kind of hearing two things. Well, one is that your approach and your processes, but the other, is around technology. So if you could kind of describe for us, what is it that is somebody who comes in with a case? What is their experience like? How is technology involved? And tell me about that.
Yeah. So the tech simply is a layer to the entire process that connects kind of everything, right? And it makes the entire process just kind of smoother. So everything from case filing to document management, evidence upload, to the discovery process, to even scheduling with an arbitrator or mediator, right? I can't even tell you how many conversations we've had where that's actually been a sticking point, where people talk about spending months sometimes just trying to schedule time with, an arbitrator or mediator, because, you're trying to coordinate 5 different very busy calendars, the two parties, their attorneys, and then of course the arbitrator and mediator themselves. So, rethinking that, payments, all the way through to the issuance of a binding decision or the issuance of a settlement agreement term sheet. Everything takes place on our platform, facilitates all of it. A lot of us come from backgrounds where we're used to building, technology platforms that also protect pretty sensitive information, including myself. And so we've also already built in a lot of the security measures, to make sure that, hey, this is a SOC 2 certified platform, information's protected, but everything lives, in one place. So you don't have kind of the emails flying back and forth, disparate systems, trying to find different documents, right? It's just incredibly easy for everybody to use, the actual technology.
So let's talk about just generally ADR. As everybody knows, with the pandemic, it really boomed. A lot of things boomed during the pandemic, and the courts too. My gosh, they even had virtual hearings, which was unheard of before. They would never do that. And so, according to Jam's, business jumped 30% in ADR in 2020. So did you see that just as a blip because of COVID, or do you see there's more of a shift toward ADR?
Probably more the latter. Certainly not a blip. I think COVID just kind of shined a light on an existing problem, which is the fact that our court dockets are just overflowing, right? And there's just too many cases for judges to just get through efficiently. And so what happened with COVID was, the 2-year delay turned into a 4 or 5-year delay, or the 1-year delay turned into a 3-year delay. And of course, people needed an outlet. But I think people are also seeing that this problem will just continue to exist, right? And that's why arbitration was created in the first place, right, years ago, and that's why the Federal Arbitration Act was passed, right, by Congress, in the 1920s, I believe, because they recognize that there should be an alternative path, right, for the myriad disputes that come up, just in society. And so, yeah, I think, now that people have seen that they can get efficient resolutions, or they can get some sort of resolution faster than they would get in the court system, folks will start to gravitate, a little more towards to ADR.
What do you wish the legal community understood better about ADR?
That there's a variety of experiences, right? And that's, I think some folks, based on one experience or another, I think allow themselves, I think, to kind of be colored, by that one experience, and not give, the ADR process a chance, right? And I think a lot of it, comes down to kind of just essentially experience with different arbitrators or mediators, experience with different platforms, their rules, right? But understanding that ADR is a way to choose kind of where you want to resolve disputes, right? And so there's different flavors, and so being really thoughtful about that, I think, one, And really, I think giving the process a few tries. That said, I think a common complaint is that a lot of times ADR, feels just way too much like court, and that it basically is just private court, right? And truthfully, that's why we started New Era. Was we've been in the ADR process, we've been to arbitration, we've also litigated in court, and yes, correct, right? We also agree that there's not a lot of difference, and so I think it's really kind of thinking about what actually what was the real reason for the good or bad experiences, right? And to recognize that, hey, this is an alternative for specific types of disputes, it's not good for others, right? And being thoughtful about how you apply the use of ADR in an organization, but also with on the consumer and employee side, that there are actually a lot of benefits, right, to a faster process, that sometimes the confidentiality as well is a good reason, right, and a positive for employees and consumers alike. And so I think understanding that there's a lot of gray too, right, in the process, and that it's not just simply black and white.
So let's talk about some of the. I'll put them generally in the category of ESG. But let's start with this. So you're on the Leaders Council of the Legal Services Corporation, which it funds legal aid groups. What's the biggest challenge for everyone, people in the U.S., to have access to justice? And does ADR play a role in this?
ADR absolutely plays a role. I think one of the biggest challenges is actually unrelated to ADR, right? I think one of the biggest challenges to access to justice is the fact that a lot of folks who need it don't know that it's available. And then when it is available, a lot of times it's not very accessible, right? And I think that's an area where ADR can play a role. Is a lot of times, and if you think about the unrepresented individual who can't afford a lawyer, right? A lot of these folks just they have no outlet, right, to resolve disputes with their tenants or with their landlord, with bill collectors, with any sort of other issues that directly impacts their lives, right? And the dispute resolution mechanisms a lot of times aren't very efficient, aren't very accessible either, right? For better or for worse, a lot of these folks, they can't just take a day off work. They can't just take a day off work to go to court and sit there for hours on end for a hearing. But the ADR process, while shorter, if you make that virtual and you make that accessible remotely, suddenly, instead of taking a day off work, maybe it's just logging in for an hour, right? Or taking a half day or something like that. And you give people more options. And then because the ADR system and process should be more efficient than courts, you also hopefully get, the individuals to some sort of resolution, far more efficiently and far faster than they would, if at all, anywhere else. And for our part, one of the things we're doing is like the way we've designed our platform from day one, actually, and it's still kind of the underlying ethos to our entire product's development philosophy is everything we build should be understandable and usable to, that low-income, unrepresented individual, right? And if that person knows how to use the platform, then everybody else is going to fall in line, right? The attorneys, the parties themselves, the arbitrators and mediators. And so we've built that, and now, it's actually, we're making it available, to legal aid organizations, and any organization that engages in any sort of these programs where they are potentially connecting underrepresented folks, right, to some sort of dispute resolution mechanism. We can be the tech behind it, and we can also provide, the individuals behind it as well, and all of it pro bono, right? So that's, that I think there's a lot, right, that ADR can do in that space.
Yeah, I think, for people of lower incomes, they may not, they wouldn't even have the resources. I mean, unless it's the type of case where you can get a contingency fee or something. And usually those kind of things, you don't want that. You don't want to be the plaintiff in that case because there's usually horrible injuries or something. but you can get access that way. But then, you hear stories, people can't afford to get divorced, or people can't afford to file bankruptcy, which I think is, you know what I mean? And I don't know that that's not necessarily something addressed by your company, but it just points out that access to courts is expensive.
It is. Yeah.
Well, along the lines, I'm keeping with my ESG thing. So, tell me about greener arbitrations.
Well, that's a pledge that's out there, among ADR providers, arbitrators, other vendors, to take steps, right, to run more just greener arbitrations. For instance, not using hard copies, using electronic copies, doing things virtually if possible, and not having to travel and incur kind of the carbon footprint of having everybody in person. Um, and frankly, it's perfectly in line with everything we're doing, right? Around everything takes place electronically. We've designed our platform, to allow people to, of course, share the documents, but also view them and use them all electronically without the printouts. And of course, everything our company's built, on the assumption that everything on our system will be done virtually. Although we're certainly, if people want to use our system to manage the entire process, but then hold a hearing in person, that's up to them. But yeah, in terms of our core principles, the green arbitrations pledge is certainly well in line with everything we're doing.
What about diversity? How important is diversity in ADR? And when I say diversity, then I'll have to ask you, what groups are we looking to be diverse? Are you talking about the folks running ADR, the neutrals, or what? Tell me about that.
I think from from an ADR perspective, the part that I think ADR providers can and attorneys have some control over is the neutrals themselves, right? Like who's presiding over your case, and diversity, I think, should be thought about in kind of every sense of the word, not just the traditional, race, gender, nationality. Certainly that plays a big role. And certainly, there are a lot of folks that are, that have pointed out that, hey, the ADR world right now is, relatively homogenous. But I think, forgetting kind of demographics for a while, I think the core of it is, does your neutral bench, does the ADR world actually reflect the population, right? Which is, it's the point of diversity. And does the person who's presiding over a case, really truly understand like all of the issues at play, not just the law and not just the business, right? But take an employment example. If it's a Gen Zer, in a dispute, over, let's say, a social media issue, something they did on social, with a company, well, you really, really need someone to also just understand the technology, understand, Gen Z mindset, be able to relate, right, to a lot of different generations, a lot of different philosophies, how people approach, kind of the world. That part is a little harder. It's something that we pay a lot of attention to and that we're being very deliberate about in terms of how we create the composition of our bench, right? Certainly we have our retired judges and retired lawyers who are fantastic and really, really understand the law. But we're also adding a lot of very experienced attorneys, to the bench as mediators and arbitrators who also, of course, understand the law equally well, but have, just some niche experience, whether it's, with certain new technologies. A good example could be, generative AI or blockchain, right? Web3, crypto, even folks who just understand kind of the back end of the financial system, right? Like when you hit trade on your Schwab account, your TD Ameritrade account, what actually happens to that trade? Like people understand all that, bring a depth of understanding to the mediation process, the arbitration process, that I think someone who just knows the law really well and of course understands business still won't be able to bring, right? And so we've been very thoughtful about kind of diversity in a very, very broad sense, but absolutely it plays a role. And I think it's really, really important, especially if, more and more cases, come to the ADR world.
Yeah, as I said before, I was talking to a jury expert, and she was saying that diversity in trial panels is not just a matter of let's do it because it's the right thing to do, but you get people coming from different backgrounds with different perspectives and different ways of looking at things, and that's valuable. And as you were talking, I was wondering, if you're handling a generative AI case, do neutrals have consultants that they or people that they can rely on with expertise that maybe they may know the law and they know something about it, but what if they don't have expertise in artificial intelligence? What do they do?
I think it's up to the neutral to hopefully go find someone who they can consult. But the problem a lot of times though is the person they consult, also maybe billing the parties as well,
Sure.
right? And
Right.
so there's also that element of getting the parties buy-in, to find the right consultant on generative AI, or more commonly just an accountant and a forensic accountant who understands accounting and can shed light on certain areas. Especially if they're not brought as a witness, then it's, I think, on the neutral.
Let's jump back to technology for a minute. What emerging technologies do you think will change how ADR is handled?
I think certainly just the one that everybody's talking about, generative AI. I think these large language models will play a big role, but
Yeah.
I think iteratively. There's a lot of different applications and use cases for Gen AI right now that can potentially make the ADR process more accessible. That can also make the lives of all the parties involved, including the neutrals, a little easier.
Is AI going to be making decisions for us?
I don't think yet. I don't think we'll get to the kind of the AI generated legally enforceable decision just yet, just because I think the industry is not ready for that yet. You still need that human in the middle to apply, soul to a decision, and thought, and that kind of human touch to a decision. But I think in some areas you'll start to see where at the end of the day with Gen AI and LLMs, it's just like analytics from 10 years ago, right? It's still about the underlying data. And so if there's enough data in a certain type of dispute, then I think you could potentially start to see, right, some form of Gen AI chatbots, things like that could potentially help resolve, I think, a lot of kind of high volume run of the mill cases. But absolutely, I think the Gen AI world will, or the Gen AI tools out there will change a lot of legal practice, and I think that's an entire podcast in itself.
Well, I think that what we ought to do just for fun is create an app where people can plug in their arguments, maybe the ones they're having at home, and it'll just spit it out and say, yep, you were right. I mean, because that's all we want. We want to know if we're right or wrong. Who knows? Certainly could save marriages or end them. It would at least be fun. But then I do think, if this is a much simpler use of it, but like I'm finding Google Bard to be a pretty good alternative to just running a Google search.
Mm-hmm.
It spits out a narrative. It's actually pretty well written, and you can also find out what sources it relied on. So you're not just wildly, but then just, I'll use it internally to inform myself and then check it. Right.
Mm-hmm.
So I think that's a much simpler thing, but I would think that would have to be the case going forward. Should it be used, where you have, like you said, the human with a soul who actually looks at it and says, okay, this is right, or this is not right.
Or even just drafting that first draft of a settlement term sheet, or arbitration decision, especially if it's reasoned. Those are all things where the human touch has already been applied, right? Like, you as an arbitrator have already made the decision. Now you're simply just giving the inputs to something, to the technology, to kind of give you at least a longer form written version of this. Of course, you still have to prompt it correctly, provide the right information, but it's a powerful tool. I actually learned that. So I wrote I'm not a doctor. I wrote a medical school recommendation for one of our externs, and I used it to help me. Right, I had a whole outline, gave it the whole outline of what I wanted to say, but then give me now put the meat to the outline, and it was fantastic. Right, I still had to make a number of edits and tweak the actual recommendation, but just simply that process of the Gen AI putting the initial meat on on the outline saved me probably at least 2-3 hours of time. And so these are things that I think, when I say iteratively, these are things that I think folks can start to use this technology for.
So then I wanted to go through a number of hot topics that have been literally in headlines that people would know about, and maybe you could just give me your take on them. The Dominion voting Fox settlement that was mediated in the final days before trial by a mediator on vacation in Europe. So what can litigants and ADR professionals learn from that case?
I think that's actually a really good example of the efficacy and potentially the impact of ADR, right? That if you have the right mediator who has the right temperaments, not just the right background, but I think the temperament's important too. You can get some of these cases to a resolution, as big as they may be. I think it's a testament to the efficacy of ADR. I think perhaps doing it sooner would have been better than waiting until just before trial, right? And the fact that it can be done virtually, and that's actually a big deal, right? I think folks a lot of times, and much less now than pre-pandemic, but there's some folks who still believe that, hey, I need to be in person because X, Y, or Z reasons. But this is a $700 million case that was, like you said, mediated remotely from someone on vacation on a boat. I don't know if he did it from the boat, but clearly remotely. And so I think it's also a good use case, just to show that, hey, if this case can be mediated remotely, certainly, other cases can be too.
You co-wrote an article on the U.S. Supreme Court case, Coinbase versus Bilski. As you described it to me, there was some discussion between justices over maybe gamesmanship or whatever that's played in litigation. What was the article about? What was the upshot?
Yeah, so this was an article back in August that I wrote with a litigator and a friend of mine around the interesting kind of dynamics in the majority opinion and the dissent, right? So of course Bilski, I'm sure folks are aware that the Supreme Court essentially ruled that if there is an arbitration decision on appeal, that the district courts now have to stay all pre-trial and trial proceedings. The thing we found interesting and that we wrote about was the discussion between Justice Kavanaugh on the majority side, and then Justice Jackson, and of course the other justices too, around their rationale for why proceedings should be stayed or shouldn't be stayed. And what was really interesting was that it all came down to gamesmanship. That was interesting because that's it was kind of literally why we started New Era was how do we eliminate the gamesmanship from litigation and just get parties to the point, right? So that people aren't just playing games just to create pain or create other forms of leverage. Just get to the point, discuss what it's about, get it resolved, right? And so you had Justice Kavanaugh talking about some of the tactics that plaintiffs' counsel and plaintiffs' attorneys would play, right, and deploy. But then Justice Jackson rightfully also pointed out a lot of the tactics that that corporations might engage in, that also are gamesmanship and that drag out, a case and drag out and kind of just make everything more expensive, right? And it was just a really, really interesting, discussion among the justices that, this whole decision really came down to, well, if we decide this way, then the other side could potentially play a lot of games. But if we decide this way, then the other side can play a lot of games. And it's really telling, that even the justices are pointing out just the gamesmanship that's inherent, in our kind of existing justice system.
Yeah, I gotcha. Well, look, you're doing some interesting work and you're trying to solve a problem also that's pretty meaningful. So let's stay in touch. And Rich Lee, thank you very much for talking with me about this today.
Thank you, Tom. Thanks for having me.
That concludes this episode of the Emerging Litigation Podcast, a co-production of HB Litigation, Critical Legal Content, VLEX Fastcase, and our friends at Lost G Media. I'm Tom Hagee, your host, which would explain why I'm talking. Please feel free to reach out to me if you have ideas for a future episode, and don't hesitate to share this with clients, colleagues, friends, animals you may have left at home, teenagers you've irresponsibly left unsupervised, and certain classifications of fruits and vegetables. And if you feel so moved, please give us a rating. Those always help. Thank you for listening.